Good morning and thank you for joining us to this webinar organized by Amicorp in collaboration with Anderson Tax. We will be speaking on estate planning and tax considerations for Kenyan individuals. Estate planning should be something that needs to be considered by everyone, regardless of their age or financial situation. With some simple planning, you can make sure that your estate and financial well-being are in good hands should you become unable to make decisions on your own. And if you pass away, everything you have, everything you possess will be allocated to the individuals and to the organizations that you choose. The more prepared you are, the easier it will be for everyone involved in this process. Without planning, your estate will be distributed in a manner which you do not agree with, potentially creating disputes over assets and creating rifts among families members in your surroundings. Hence, the goal of each individual is to design a plan to address those state taxes and also to distribute those assets which are suitable for everyone. I am now going to introduce myself. I am Kajal, a senior employee working for Amicorp Dubai office and has been with the company since the past 8 years. I am into business development and my core market are the Eastern African countries, whereby I also look at Seychelles and Mauritius. I have a master's in law and I'm also ICSE qualified. I will now give the opportunity for my other partners in this webinar to introduce themselves. David.
Thanks, Kajal. Hi, my name is David Willis and I'm the Managing Director of the Amicorp New Zealand office. I've been involved with trusts for over 20 years now, all aspects of administration and establishment across multiple jurisdictions around our group. It's a pleasure to be involved with this webinar.
Thanks, David. Brian, can you please introduce yourself?
Thank you, Kajal. My name is Brian Kangeta. I am a Director Tax Services at Anderson Tax. I am a lawyer. I have a master's degree in law and I'm also an accountant, a qualified certified public accountant. Thank you, Kajal.
We'll now go through the topics which we'll cover in this webinar. We'll first define what is a trust, and then we'll try to understand as to why estate planning is important and why it matters. We'll also go through the different types of trusts. We'll try to understand as to why international transparency is very important to estate planning and how it is applicable. And we will also speak on Kenyan tax and legal consideration. Now, Brian, can you please give us an introduction about Anderson Tax?
Thank you, Kajal. Anderson Tax is an international organization, an international tax services firm. We focus on providing tax services to both individuals as well as corporate entities. One of the arms of our tax services is what we refer to as private clients and family wealth. And the motto that we always recite with regard to private clients and family wealth is that at Anderson Tax, we understand that when you are accumulating wealth, it is not just a matter of how much you make, but also how much you keep. So we find it very important that our private clients are able to keep as much as they make in the course of running business or in the course of their day-to-day activities, not just making much, but also retaining as much as possible. As I've mentioned, our services are in the range of tax professional services, So we do assist our clients in the area of tax compliance, and we also offer tax advisory services. In this webinar, since we are focusing on estate management and wealth management, our main area is to look at tax advisory services as opposed to tax compliance services. And in this tax advisory services, one of the main facets that we also have in there relates to managing tax disputes that may arise with the revenue authorities. So in this regard, we assist our clients to manage any tax investigations that may be conducted by the revenue authority. We also assist them in regularizing their records with the revenue authority. And in case those disputes end up at litigation, we also offer tax litigation support. This is very important for our clients who may look to structure their operations in a way that they manage their wealth so that they try and keep as much as possible as opposed to just making and letting it go. We find that some of these matters end up being investigated or in dispute resolution with the revenue authority, and we therefore offer the necessary support. Thank you, Kajal.
Thank you so much, Brian, for the introduction on Anderson Tax. I'll now be giving a brief introduction about Amicorp. We are a leading global service provider whereby we offer services to several corporates, international advisory firms, private institutions as well as financial institutions, investment firms, and family offices. We are experts in cross-border transactions, whereby we have over 750 specialists who will then go and advise and implement structures for clients. In so saying, we have several alleys of business. We have our corporate services, we have our private client services, we have our business support services, we have our financial services, our fund services, and also the corporate and regulatory compliance services. Now, Brian, can you just explain to us as to why estate planning is very important for the individuals in Kenya, and why nowadays estate planning is becoming a key word for everyone?
Thank you very much, Kajal. There are a few myths that we will be looking to demystify during this webinar. Some people believe that once they have a will, that they are sorted, they don't need to do anything else. I've already executed a will, I have handed it over to my attorneys, so I am sorted out. Is this a myth or is this a fact? We shall look into that. If you have already allocated and distributed your property, should you rest easy? Should you say that I am done? I have done what is necessary because I have allocated and distributed my property? Some say that their dependents already have their own property. They don't need to inherit or manage property from their from people that they will inherit from. And so if your dependents already have their own property, do you need to stress about managing your wealth or assets going forward? Some people will ask, why do we need to even be talking about estate planning in the first place? Why do I need to think about managing my wealth or managing my estate? And we will then ask you a question back. Why should you not? As I started off, I mentioned that one of our mottos is that however much you make, you should also look at how much you keep. So if you have been in the process of making all this wealth, why should you not then think about how to manage it going forward, or once you leave our planet Earth. If you are able to manage your assets, manage your wealth going forward, we believe that it gives you peace of mind. We believe that it avoids family disputes, as Kajal already alluded to. It allows you to efficiently hold and grow the portfolio of wealth or assets that you have built over time. Why would you let someone else manage your estate or manage your assets once you're gone, while you are the one who created or built that estate or created those assets? So then comes the question, what options does one have if you were to look into creating a will or managing your assets? What options are there? These options allow you to appoint trusted trustees or administrators, which you cannot do if you do not think about this early or start creating, managing this estate planning. So these options allow you to appoint trusted people who will act as trustees or administrators of your estate. It allows you to choose and specify the beneficiaries of your estate once you're gone. It allows you to reward any deserving dependents or beneficiaries, as opposed to letting your estate be divided between people who you might not want to benefit from the estate. And if you are a charitable giver, it then allows you to do that and give or distribute your estate to charity while you're still alive. What is intestacy? Intestacy is dying without a will or an effective will, because you might have a will but it is not an effective will. In that case, you will be deemed to have died intestate. If you do die intestate, then your property is first distributed to your immediate family. So we will first look at who are the immediate family of the person who was deceased. If we do not find that group of people, then we go to the extended family and try and see who else can benefit from that estate. And once that is exhausted, we then say that whatever property remains is to be distributed to the state. And these are the consequences of someone who does not take care of his estate planning from the very outset or early enough. So what is a will? As we have mentioned, you either need a will or an effective will. A will should be signed by the person who creates the will or someone that the person has directed to sign. The will also needs to be attested to by two witnesses who are not beneficiaries. And if the beneficiaries do get to attest, then it means that their signatures should also be attested to. Any witnesses to the signatures should be above 18 years of age, and the will should name at least one executor. Then we shall say that you do indeed have an effective will. So what exactly are we looking at when we say that we are going into estate planning? What exactly do we want to debunk? What exactly do we want to demystify? There's a myth that says that wealth does not pass 3 generations. If you're able to manage your estate properly, manage your assets well in advance, we believe that you should be able to bring down these walls that say wealth does not pass 3 generations. You should be able to build and manage your assets in a better way, because the holding of those assets will be well structured, and then you should be able to use those structures to build upon the assets that initially formed the estate. You should be able to manage the wealth preservation. If you're going to preserve wealth, you should be able to say that, yes, I'm preserving this for my dependents who will come in at a later stage, or I will use this and invest it in order to generate returns, and so on and so forth. So these structures allow you to manage your wealth preservation. As we've already said, it is also a good tool for succession planning. In determining who will take over your assets, who will take over your business, you can do that early enough when you start managing your assets and your estate. It also allows you to transfer your assets or estates to the next generation or to charity, as we've already mentioned. And you can then do this in a responsible and sustainable manner because you have the time to think about this early enough, you have the time to seek advice and implement the correct procedures.
Thank you so much, Brian, for that. Here are the points as to why estate planning really matters. As I mentioned in my introduction, we really need to plan our estate planning. So some of the points are for successful estate planning are firstly to protect your family, to identify your beneficiaries, to provide for special needs of your family members, for example, someone who is handicapped, to safeguard spendthrift persons, for forced hardship planning as well, for example, in case you have assets which are in civil law or where state forced hardship planning is really enforceable, to protect your assets and wealth that you have accumulated over your lifetime, to protect your business after your demise, for profit management, that is to allow your next kin to get their assets after your demise, not to wait for a long time, and lastly, to manage estate assets and inheritance taxes. Why is that? It's because some of your assets might be in high jurisdictions whereby the laws of taxes are really, really complicated and they are high taxes. Now, we'll go to David so that David can explain to us as to why a trust is important, what's a trust, and what are the tax considerations surrounding a trust. Up to you, David.
Thanks, Kajal. As you've heard, estate planning is very important. And one of the main features that we see being used, or one of the main solutions we find with estate planning, is a trust. So what is a trust? Well, a trust is a special legal relationship. It's generally in writing. It's under which one or more trustees hold property for the benefit of the beneficiaries or charitable purposes. It's a special relationship because it's an obligation. It empowers a trustee, has obligations which bind them to deal with the property and hold it for the benefit of beneficiaries. And it's separate property. So it's while they legally own the property, they hold it for the beneficiaries. And those beneficiaries do have duties, do have obligations. The trustees have obligations to those beneficiaries, and those beneficiaries can enforce those duties on the trustees. So just looking at a few trust features, it's not technically, it's not a legal entity. It's as I said, it's a set of obligations. It's an agreement. It's a principles-based relationship. It does split the legal and beneficial ownership. So assets, while they're being held by the trustee, are beneficially owned, or beneficially the rights of those assets are still with the beneficiaries who can be named. As Brian mentioned earlier, you can decide who those beneficiaries could be. Other parties involved in a trust will be the settlor. That's the person who actually puts the assets into the structure, into the trust, or sometimes can be known as the grantor. The other people involved could be a protector, which we can show you very shortly what they are. Beneficiaries are the people who benefit, and investment advisors if you wish to have financial investments and you wish to have those invested in some way. Now, these all can be corporates or they can be individuals. There's no particular restriction. The protector and the investment advisors, and there can be other committees as well. These can give extra peace of mind to the settlor and the beneficiaries in terms of the management of the trust and the security of the funds. The trustee can be very flexible based on specific circumstances of a family, as well as dealing with the particular choice of law that you have. These can be discretionary, irrevocable, or revocable. Some of these terms are quite legal in nature, but basically revocable means you can revoke the trust, you can bring the assets back, irrevocable means you can't do that. And discretionary means basically the trustee acts on instructions within the trust deed and things called letters of wishes or directions, which can be given to the trustee and they can decide from time to time. Some of these flexibilities can be restricted by each law in the jurisdictions which we're going to mention. Some of them are more flexible than others. That's just the way they're designed. So lifespans are also important because each trust jurisdiction generally will have a life period. So with a company, it lasts forever. With trusts, they generally can have some sort of life period. Now that means that after a certain period of time, say 125 years, the assets have to be distributed to beneficiaries. Some jurisdictions, however, have very, very long periods of time, and some of them are actually unlimited. So looking at a typical trust scenario in diagrammatic form, so you will see the trust is the blue triangle in the middle of the screen. The settlor on the left, he is the person or company, could be, contributing assets into the trust. The trustee at the top, we've got Amicorp, they're basically supervising the trust with the protector supervising the trustee. The protector is there basically to watch over and make sure the trustee is doing things in accordance with the deed and wishes that's been given from the settlor. So the protector, the trustee might go to the protector to get permission to do certain things. That's not always the case. Not all trusts require protectors, but it's quite common. The beneficiaries can be, as I said, they can be individuals, family members of your choice. There can be corporates involved in there as well. And they're the ones who receive the distribution of interests. Now, trusts can basically hold any type of asset that can be legally held. Now, these can be companies, they can be insurance policies, it can be property, real property, land, buildings, aircrafts, financial bank account, anything that you can hold as a person, you can hold in trust. So you get a lot of flexibility in what you can put in. So some people just think of trusts as financial vehicles. Well, they're actually going to hold businesses as well as your private wealth. So you can have business succession, which was mentioned earlier, as well as planning and to deal with your wealth in the future. So servicing, I mentioned different trust jurisdictions. On the map, you'll see the red dots. The red dots represent the trust jurisdictions that Amicorp operates in. And on the next slide, we'll just push through to see where we actually offer those, so it's a bit clearer. So the trust law is offered, you can see them in the bullet points. The Barbados, BVI, Bahamas, Cayman, India, New Zealand, Mauritius, Singapore, UK, USA, South Dakota. Now, the asterisks, you're probably wondering what the asterisks actually mean. The asterisks are basically where there's jurisdictions that offer more than one law. So the BVI, our laws in the BVI, we manage those from our Barbados office. Our Bahamas office is looked after. The laws of Bahamas are dealt with through Cayman and also Switzerland. Switzerland isn't mentioned on there because the trust law, it doesn't have trust law yet. So Swiss trustees are well used, and they can offer any type of law with them. It's quite a technical thing. Can be a little confusing, but Swiss trustees can have any law underneath them. So they could have a Swiss trustee with a New Zealand law. Swiss trustee can have a Cayman law. And our South Dakota office is also managed. It's fully licensed. We have people in South Dakota, but we do a lot of administration from the Barbados office. So some of these jurisdictions are, as I said, quite flexible in different types of laws. So one of the things which is quite interesting is the PTC. Now, a private trust company allows considerable more control over a professional trustee. It doesn't mean it's not professional. It just means that the individual, the settlor, or family members can actually be on the board of the company which acts as the trustee. So all the trust features and terms which we've mentioned earlier still apply, but the individuals, the settlor or family members, or chosen professional advisors can sit on the board of a PTC, and they can act as the trustee. And that has a number of benefits. It gives Control. If you have operating assets in your trust, you're going to have greater understanding of what's happening with those operating businesses, and you can make decisions quicker. You have more of a family office feel because maybe you have different family members on the board, and then it's quite a good vehicle for high net worth individuals having lots of different assets that they want to look after. So we've mentioned there on the slide, we have operating businesses, aircraft, insurance, real estate. So if you have a very broad range, it's a good way of managing, controlling that. The jurisdictions that we use with PTCs, we typically do use them in a lot of jurisdictions. New Zealand's quite a good jurisdiction for PTCs. It's flexible, it's easy to set up. Singapore is another jurisdiction that we use, and our Caribbean islands also can offer PTCs. Corporate governance is the key with a PTC in most places where it's based. The limited liability company needs to meet its local legal and regulatory obligations. So it's very important that you work closely with the administrators of that company. Amicorp would be a partner with you to make sure that those obligations are met. Some jurisdictions require a local director. As I mentioned before, in New Zealand, they do require a local director, which would be an Amicorp employee, which work closely with the family in dealing with matters of the trust, making sure things are documented properly, and resolutions and corporate governance is maintained. Shareholder considerations is also very important with the PTC, just to understand who can be the shareholder. You can be very robust with the shareholding, so you could have something called a purpose trust, or you can have individual or another entity as the shareholder. One other feature which is also quite important with trusts is the reserve powers trust. And what this is, it allows the settlor to reserve certain powers to itself to do certain things. The typical reserve power is investment powers. So the settlor then can make decisions at the investment level on all sorts of types of investment, which gives them a lot of comfort that the investments are being managed the way they want them to manage and invested in things they want to be managed with. The protector mentioned on the slide is also important. So the trustee then, if there's a distribution or something of those assets, then the protector would need to consent. So again, the settlors can have additional control or perceived control without actually having the control through a protector who is usually a trusted person, or could be a lawyer or accountant, family friend, or anybody else. Those reserve powers operate specifically a law in some jurisdictions. Singapore is notable for having very strong reserve powers. That really means that there's no impediment to the trust being seen as a sham or busting the trust because the settlor has power. Other trust jurisdictions, you can draft those provisions into the deed. So New Zealand, for example, we can actually draft trust provisions in there, which allows settlors to have those specific powers. Now, I just want to mention transparency now, because with all these international jurisdictions and trusts and estate planning, it's important, as I mentioned before, for corporate governance, but it's also very important to make sure that you understand regulation and the also international transparency aspects. So jurisdictions will vary in terms of what they require for establishments of trusts. Some jurisdictions require formal registration. Some have registers. Some require documentations to be provided to them. Specific trustee licensing in a number of our jurisdictions that we operate in is really, from a trustee side, what we require from a due diligence side, and they're regulated to make sure they're doing things properly. They also deal with anti-money laundering requirements, whether it's source of funds, transaction monitoring, and a number of other things. International transparency is also quite a hot topic. Many years ago, it started out with something called FATCA, which was a US-based piece of legislation where the US wanted to know everything about all its citizens overseas. The rest of the world thought that was a good idea, and they brought out something called the Common Reporting Standards. Something you'll see is known as CRS. CRS is basically FATCA on steroids, meaning that every other jurisdiction around the world is wanting to transfer information between each other. So jurisdictions who are signing a treaty, multi-cooperation agreement, will be signing up to CRS, and then each country has to decide whether or not they think it's secure enough to exchange information. So it's important to know that certain people who are known as controlling persons will be, their information will be exchanged between jurisdictions. Controlling persons are typically the settlor and protectors, and if a beneficiary has received a distribution in any particular period of time, they will be disclosed. Discretionary beneficiaries, however, are not, while they have not received a benefit. So that's quite an important distinction. Settlors and protectors are always reported. Protectors is a bit of a contentious one, but it is nonetheless in the law that they have to be reported. PTC requirements, they do vary based on applicable law. As I mentioned earlier, New Zealand has a requirement for local directorships. Singapore doesn't, but they have to have a local agent, say an Amicorp partner, who will deal with anti-money laundering requirements, say in Singapore. So corporate governance is obviously crucial. How can Amicorp help? Amicorp has a number of services I mentioned before. We can establish and set up the trust based on working closely with the advisors like Anderson Tax. These can be PTCs, as I mentioned, or various different underlying entities. We can act as corporate trustees or directors with PTCs and registered agents. Administration of those entities to make sure corporate governance is maintained, and constant communication with clients, whether settlors or beneficiaries. We can deal with all the accounting and bookkeeping, all the international requirements, as I mentioned before, for reporting, which is CRS and FATCA. We also offer a quick bank solution. We have a Amicorp Bank and Trust, which is very, very useful for trust accounts to be set up and other accounts to be created within our client base, which is a Barbados licensed bank. So it's actually quite a nice offering within our umbrella. But just jurisdictions we've mentioned before, and if you have any questions on those, you can contact any of us at any time. So I'd just like to hand back to Kajal now. Thanks for listening.
Thank you so much, David. I understand that there are some common questions which are asked by many individuals to the tax advisors and legal advisors. Brian, would you be able to just let us know what are those questions?
Thank you, Kajal. One of the common questions that we have faced is assuming someone has set up a trust that already holds their business interests, and maybe it also identifies the dependents and beneficiaries. Would such a person still be required to prepare and have in place a will over and above the trust structure?
Thank you for the question, Brian. Actually, both will and trust are estate planning tools. You should always have a will, even though you have a trust. Actually, the will will deal with your estate planning, and the trust will deal with the assets which have been contributed over your lifetime or which are to be received in the future and which are to be held for the trust. In so saying, you can always link your will to your trust, so that any assets not in the trust, at your sad demise, those assets can then be passed to this trust itself, or it can be managed through any other means. For example, donation to charities or to relatives who are not beneficiaries of your trust. However, it might be that your estate would still go through probate formalities. Hence, a trust is very important to ensure that business interests and assets held through this tool do not come to a standstill during those probate process. Further above, as I mentioned before as to why estate planning matters, in case you have assets in jurisdictions where trusts are not recognized, for example, the Middle East, where I am actually, that is in the UAE, then it is strongly advisable to use a will as a tool to manage such assets upon your demise. Thanks, Brian.
Thank you for that response, Kajal. Another question that we have commonly faced is someone inquiring what is the benefit of setting up an offshore holding structure compared to setting up a structure locally? Why would I want to set up a structure outside the country as opposed to having a structure in Kenya, for example, that will hold my business interests?
So, Brian, most of the times when clients come to Amicorp for any kind of advice on estate planning, right, we ask them several questions, whereby then we advise them what's the best directions to then establish that. And those clients are most of the time persons who have global assets, you see. And basically, when we undertake our own kind of investigation as to and undertake, try to understand as to what will benefit them, there are several kind of points which we consider, and these are as follows. So most of the times we have to look at for jurisdictions which have strong banking relationship. For example, clients who have many liquid assets, that is cash, or they have portfolio. We have to look at for a jurisdiction which has strong and friendly relationship with most of the countries. When I say that, I'm speaking about countries which have double tax treaties. For example, you can choose a country like Singapore, which has several tax treaties with the Eastern Asian countries. So this point is very important. Why I'm saying that is because most of the time this holding structure will have several subsidiaries, right? And you will engage into business relationship with that. So this point is very important. Then, of course, you will choose jurisdictions which is economically and politically stable. That is, you will want your trust or your holding structure to be alive in the next 20 and 30 years, and the laws to still apply. You don't want to go and establish something whereby there are several changes in the law. And fourth thing, you will need to also think of a place where it has a very strong law regime, and whereby enforcement of agreements can easily be carried out, whereby there is basically a law which is recognized among the holding structure and also all the other subsidiaries. But nowadays we're speaking about a lot about common law, where common law applies, right? For example, there are some countries, some clients who has assets in countries which have only civil law. So these are the factors which you really need to take into consideration before you set up your state, your trust, or even an offshore holding structure. There can be also factors which we also think might be or necessary, is basically where those beneficiaries or even those individuals have a wide range of investment opportunities, and where they also see that the taxes are beneficial for them. So these come as secondary, but they are also very important when Amicorp, we as a global service provider, we go and try to basically give advice to the clients. I hope this answer was good for you, Brian.
Thank you once again, Kajal, for that response. Maybe one other question that comes to mind, considering that you have spoken about the possibility of setting up structures in a number of countries. We've looked at New Zealand, we've looked at the Arabian world in terms of the UAE, we've looked at possibilities in Mauritius, or even the islands, for example. What factors will assist a potential investor or a potential client in settling or choosing one jurisdiction that can serve as the country in which they hold the parent company or the parent structure? If we are talking about trusts, for example, what factors should I be looking at to assist me to settle on one jurisdiction as opposed to another?
Thanks so much for this question, Brian. As you correctly mentioned, Amico, we offer trust services in approximately 10 jurisdictions. And whenever we advise our clients, right, so as to basically which are the places which they will need to establish their trust. So it depends on several factors. Apart from the roles I mentioned in your second question, I also would like to mention that it also depends on the citizenship and also the residency of the settler as to where he's a tax resident. Basically, how many passports does he have? And also, we also need to understand also where the beneficiaries are residing. Are they in a place which is highly taxed? Are they in a place which is basically lowly taxed? Or are they in a place where common law doesn't apply? Or so these are the kind of several factors which we need to consider. And apart from that is basically what the status of the assets, that is the location. Sometimes clients might have assets in US, and as you are aware, US have different laws with regards to inheritance, with regards to estate planning. Then the third is, as I mentioned in my second answer, is the banking relationship which the client would like to have for the trust. What we can see at the level of Amicorp is more clients are putting liquid assets in the trust, that is the cash or any kind of bond they have. So basically they will need to choose one jurisdictions which basically have the most private banks out there. For example, they would choose places like Singapore or even Switzerland. Okay, and also what is also necessary is the trust periods. Basically, when you want to establish a trust, you want to establish that for a very long time. In some places, in some jurisdictions, the trust can go up to 99 years, and in some it can go more than 100 years. Hence, it all depends, on what are what the clients really need. And also, some clients will still like to have control over their assets, even though they have basically settled all their assets into the trust. These are called reserve powers, and they are only allowable in some jurisdictions, for example, New Zealand. So this is something which we also consider whenever we think as to what's the best jurisdictions to basically advise the client. And fourth, also, as I mentioned, right, in case a trust has several beneficiaries under it, they have several companies, so clients would definitely want to avail of double tax treaties. Hence, it's also important to choose one jurisdictions which have several agreements, several double tax treaty agreements with other countries. And if we go and have, let's say, a client who's from Eastern Africa and they want to choose one country which has several double tax treaties, right? Then they will consider between UAE and also basically Mauritius. But now, as you're aware, we are seeing Dutch foundations becoming very popular as well. So, Brian, these are the several kind of factors which basically, Amicorp will speak about or will consider before we assist you and your clients in choosing a specific country as a holding jurisdiction or as a holding kind of structure. I hope I've answered your question, Brian.
You have, Kajal. Thank you very much. I will now hand over back to you to wrap this up.
Thanks, Brian. Dear audience, thank you so much for being with us for this webinar. We hope that we've been able to enhance your knowledge with regards to estate planning and also some tax consideration on Kenyan individuals. In case you have any questions, please feel free to contact any of us, that is Dave Willis, Brian Kangeta of Anderson Tax, or myself. And I'd also like to take this opportunity to thank David and Brian for their time for this webinar. Thank you.